He isn't here. He has not responded to discovery. Plaintiff's entitled to the default judgment. Mr. Roberts, so a half hour late. We'll get to you in a minute.
I appreciate you letting me have my camera off today. I'm a mess.
Well, I'm a mess on my best day, so we'll do the best we can.
I know that I have the debt. I took the car in to be fixed. They refused to fix it, where it was a burden to try to pay for a car that I'm unable to take my children in.
J.D. Byrider was the car dealer and didn't respond to discovery, and you were late for your own hearing. So I entered a default judgment against you in the amount of $10,415. Careful, I don't know what you're doing, but look like you're about to pop a blood vessel.
Today, we have two hearings on two cases in St. Joseph County, Michigan. The first one, which is also the last one, is a defendant who might have had a meritorious defense to the plaintiff's claim had he answered the interrogatories and shown up on time for court. And when he does show up, he's a hot mess, as you saw. The hearing in the middle is the natural result of when a buy here, pay here outfit sells a substandard car to a single mom without much credit or resources and who doesn't know any better. Read between the lines on this one, because you'll see Judge Middleton basically kick it down the lane for 2 months, which is his way of telling the plaintiff he doesn't like their business model. Let's roll, nerds.
It is 8:30, early on a Monday morning. I appreciate your being here. I don't know how many courts you go to that start this early, but we get off with a bang on Monday morning. I'm going to call the case. I'm expecting someone to show up on behalf of the defendant unless you've worked this out, but let me call it. It's entitled Liberty Mutual Insurance versus Bradley Roberts. The file number is 241073GC. We were here previously in this matter in December 16th of 2024. The claim is for $10,415.02 plus cost, interest, and attorney fees. This had to do with an automobile accident with an uninsured motorist. I guess an insured motorist. And Liberty Mutual Insurance is suing that other party. But it was confusing. When we were here in December, the vehicle was owned by someone else, Cindy Vandegrift. The insurance was in Bradley Roberts' name. He wasn't driving it. The vehicle was titled to somebody else. The insured, she wasn't driving it either. And so there was no police report. We didn't exactly know what was what. So we adjourned the matter for further discovery from December to March. Mr. Duquette, you got any update for us?
Yes, we sent out discovery on February 24th. I do not see that we have any responses back to that. And at this point, that puts us past the 28 days. So if the defendant fails to respond to discovery, there's kind of the issue of those requests to admit being deemed admitted.
All right.
I think that with that issue on the table, I think plaintiff would request a motion for summary date.
Well, what about just a default judgment for the defendant not appearing for the pretrial?
If the court's willing to go that route, I would definitely request that today.
Because as convoluted as this is, he was the insurance holder on the vehicle. The insurance had lapsed. It wasn't his name, although he wasn't the owner of the vehicle, the titled owner. He was the one. He got notice and he isn't here. And my fear on these things is about 2 minutes after we hang up, they show up. So Mr. Roberts, I'll grant your motion for default. Let's calculate the numbers.
I have damages in the amount of $10,415.02. Associated court costs in the amount of $232.13, and then the $75 statutory attorney fee. So my total judgment amount shows $10,722.15.
I don't believe I have an order in here, so I'd ask if you would send me one.
Certainly do that. Would you like it under the 7-day rule?
No, you can just email it to me.
Okay.
3B civil, I think this is in your library, but let's take a look. 3B civil at stjosephcountymi.gov.
3B civil at St. Joe County.
St. Joseph County, mi.gov.
Got it.
All right, is that the only one you have here this morning?
Yes, that is all I got.
All right, if he shows up in 5 minutes, I may call your office and ask you to log back in. But at this point, they're not here. He was aware of the date. He has not responded to discovery. And the plaintiff's entitled to the default judgment. All right, thank you. I'll see you next time.
Sounds good. Have a good rest of your day, Your Honor.
Thank you.
Good morning, sir.
Good morning. Are you Kelly Smith?
Yes, sir, I am.
All right. Mr. Roberts, are you here? No, we'll deal with this case first. Let's go on the record. Good morning. It's early on a Monday and we're here at work. The title of this case is HZAC Inc. versus Kelly D. Lidle. Good morning. Mr. Roberts? Mr. Roberts, would you take your hat off? You're also a half hour late for your hearing. We'll get to you in a minute. Ms. Lidle called in this morning and advised the court that she lost power. And we asked her to just call in. So thank you for that. Can you hear us?
Yes, I can hear you. I appreciate you letting me have my camera off today. I'm a mess.
Well, I'm a mess on my best day, so we'll do the best we can. There was a lot of storm damage in and around St. Joe County, and a lot of people are still out of power.
Yes, sir.
So let's talk about this matter. The file number, as indicated, is 241791GC. Attorney Anthony Shivelbein.
Good morning, Your Honor.
Is here on behalf of the plaintiff. And this is a claim regarding the sale of a car and a repossession of a car. We get lots of these. The claim is for $8,109.01. And the defendant was served with that lawsuit, and she filed an answer, a letter, which we accepted as an answer, indicating her current financial situation, which is not good because of medical issues. Mr. Shivelbein, have you had an opportunity to discuss this all with the defendant?
I am checking to make sure, but I believe Miss Smith responded back to our office that she was by email back in January, stating that she was unable to do any sort of payment arrangement. If that's changed, I'm sorry, Miss Smith, I'm happy to discuss that, but I was working under that knowledge, so that had no further communication sent by my office.
Ms. Smith, is that your position presently? You're not in the ability to make any payment on this?
That is correct. I've been off work since September 22nd of 23 due to this medical condition. I've filed for disability and was denied, excuse me, denied twice.
Are you going to apply a third time?
I am, yes, sir.
Do you have an attorney helping you?
The Michigan Disability Attorneys, I believe is their name.
Okay. Well, this is a situation of essentially it is what it is. You acknowledge the debt, but indicate that you don't have the ability to pay. You can either just acknowledge the debt or the plaintiff can file what's called a motion for summary disposition, contending that there is no material issue of fact and there is no defense. The fact that you don't have any money isn't a defense to the fact that you owe money. But if you don't have any money, you don't have any money. They can't collect if you have no income. However, your circumstances could change. Your health could improve. You could win the lottery. You could inherit $1 million. And the judgment would be good for 10 years. So you can either simply accept that you owe the debt, or we can set this matter for a hearing on a motion for summary disposition, indicating that there is no issue of fact. Do you have a thought on that, Ms. Smith?
Honestly, I don't know. I know that I have the debt. I took the car in to be fixed. And they refused to fix it. There was exhaust leaking and making my children sick. My daughter with asthma got really sick. So I stopped driving the vehicle, and then I was able to pay for a few months from what I had saved after I was taken off work. And then I just got to the point where it was a burden to try to pay for a car that I'm unable to take my children in.
Yes. Well, this is often an issue that people have issues with the car. The problem is this is the lender rather than the car dealer. JD Byrider was the car dealer, and this company is the people that lent the money.
Let's see.
But it's very common. All right, Mr. Shovelbein, perhaps the plaintiff should just file a motion for summary disposition.
Okay. Yes, I can do that. And in that case, do you need a written or oral request, or is that just going to be entered into the entry by your court?
I'll indicate you have 28 days to file the motion for summary disposition.
Okay.
Defendant has 28 days to respond if she wishes.
Okay.
So that's about 2 months. So let's take a look at the calendar. April, May. Set this for 9 a.m. Further pretrial and motion for summary disposition. For June 23rd. At 9 a.m. Right now, Ms. Smith, you don't have to do anything,
Okay,
but they're gonna file a motion that says what I said. There is no material issue of fact, and you have not stated a defense. And then you have a chance to respond to that. But this comes up a lot. The people have issues with the car, but this is the lender rather than the car sailor. They are closely connected, but and so the fact that you got sick and weren't able to pay isn't a defense to the fact that you owe the money. If you have a defense that you wish to raise, you can and file it as an answer to the summary disposition motion. But we'll
Okay.
hear this matter further on June 23rd at 9 a.m. via Zoom once again. Hopefully you have your power back by then. And thank you for agreeing to continue this rather than adjourn it. We'll keep the matter moving forward. We're about 2 more months out. You'll get this motion in the mail. Are you still at the James Drive address?
yes, sir.
All right. You'll get that. You can take a look at it, see if you wish to answer it. If you don't answer it, that's all right too. We'll have a further hearing on June 23rd at 9 a.m. via Zoom.
Okay,
All right. Do you have any questions?
I do not.
All right, Mrs. Shivelbein, anything else from you?
No, is there anything else needed from plaintiff's counsel, Your Honor?
No, I'll just wait for your motion. Thank you.
Thank you very much.
All right, Mr. Roberts, can you hear me? Can you hear me? I thought I unmuted your mic. For one thing, you're a half an hour late for your hearing. It was set for 8:30. You came in at 9 o'clock. The attorney was here at 8:30 and I was here at 8:30. And we waited around for a while for you to show up. And I was afraid that you would do this. It's a huge pain in the neck when people don't show up on time. We have things scheduled every 15 minutes or every half an hour. So we had a hearing and waited for you. And you're here now, but you don't have any sound. The matter was adjourned from December 16th to today. The company, through their lawyer, sent you a set of interrogatories and some discovery material to ask you some questions. You had 28 days to respond to those questions and you did not. And then you didn't show up for the hearing. So you didn't respond to discovery and you were late for your own hearing. And you're sort of not exactly here now. You can hear me, but I can't hear you. So I entered a default judgment against you in the amount of $10,415 plus costs for a total of $10,722.15. When you get that, I guess you could file a motion to set aside the default. You have 21 days to do that. Two problems. You didn't show up on time. And then when you did show up, I can't hear you. And the third problem is they served a set of discovery subpoenas or depositions on you and interrogatories. You didn't answer them. So it was your contention that you didn't own the vehicle that wasn't insured and that you weren't driving it at the time of the accident. However, it was the insurance was allegedly in your name. There may be a defense to this, I don't know, but you're going to get in the mail an order that says you owe $10,722.15. If you wish to object to that, you have 21 days to file the motion to set aside the default. You need to have a good cause for failing to appear. Now, you were a half an hour late, but you're not even really here now because I can't hear you. Half an hour isn't the end of the world, but we were here twiddling our thumbs waiting for you to show up. So, I do have a default in here. So you'll get that order of default in the mail, and then careful, I don't know what you're doing, but look like you're about to pop a blood vessel. Okay, lift that up a little higher. I called and walked home. All right. Well, tell me that in your motion, but no one told me that you had called. Let's see if they sent me an email. I was sitting here waiting. Anyway, you'll get that in the mail and you can respond to it. You have 21 days after you get it to file that motion to set aside the default. All right, Mr. Roberts.
Thank you for watching. If you enjoy watching this content, please like and subscribe. It helps new channels like this one gain exposure. There is a lot more good court to come, so if you like what you saw, tell your friends. If you didn't, tell me and let me know what you'd like to see and how I can improve. Thanks.